Bertrand Russell and Albert Einstein issued their manifesto at the Bosch conference, signed by many other scientists, that any war has great risk of developing into a world war and then into the use of nuclear weapons. And therefore we can no longer have wars. Instead, think of your humanity and forgetfulness. In the Pacific settlements, so I'm very glad you're here today. And I hope we can support all the many states who have already ratified this particular jurisdictional power of the international court of justice. And we hope to support their efforts to achieve that we will get universal acceptance of the jurisdiction of this court. It's very important point, and I'm very glad that I many people here who can talk about this in much more detail. This is my colleague Aotearoa. I should say I'm here talking from not maybe with the lawyers from the nuclear policy.
So welcome everybody. My name is Alan Ware. I'm with the World Federalist Movement, the World Future Council, Aotearoa Lawyers for Peace, and Parliamentarians for Nuclear Non-Proliferation and Disarmament. To everybody online, we're still sorting out the sound that was working previously. So we're just checking to get it back online. That's been with us for a moment. Sorry? Is it now working? Can people online now hear? I think we now have sight. Thank you. So welcome everyone.
Those in the room, you need to either mute yourself or turn off your connection. Otherwise, you're going to keep getting that echo.
Okay, so let's move. Anyone on what laptops are joining in the room?
Exactly.
Move.
Just connect yourself.
Okay. Thank you for bearing us with us while we just sort out the technical. I think we're now sorted. Can people online hear? Tadashi, Nisham? Yes, you're online, and we can hear you.
Can hear you.
Thank you very much. So we're joined by, it looks like, 170 people online, and we have quite a full room here today. There are still a few seats at the table available if someone behind do want to come to the seats at the table. I want to thank you very much for joining us today. This is an event on legal alternatives to war with a focus on enhancing the use and jurisdiction and effectiveness of the International Court of Justice as a primary. Okay, we're fine. Sorry. As a primary international judicial organ to help resolve international conflicts, advance the application of the rule of law, and prevent war. And we're in very difficult times, as no doubt all of you will know, with increasing tensions, with a range of unresolved conflicts at the international level, some of which have expanded into war, armed conflict. So these are questions of what role can the International Court of Justice in particular play, but also other international tribunals. It's also related to similar work or related work in the International Criminal Court. And today we have experts that are both in the international, from the International Court of Justice, also the International Criminal Court, and other ways of applying international law. As I mentioned, a primary focus today is on the International Court of Justice. We're really happy that we have some representatives from some of the like-minded countries. From like-minded countries who 2 years ago released a declaration on acceptance of the jurisdiction of the International Court of Justice. So we will hear from some of those representatives from some of those countries. There are now 33 countries, I think, have endorsed the declaration. and that is also part of a broader effort from the like-minded countries and that also from civil society in exploring the value of the International Court of Justice and looking not just at acceptance of compulsory jurisdiction of the court, but also the use of the court through other mechanisms, such as through the use of treaties, international treaties, where there is articles on the use of the International Court of Justice, through mutual agreement by states, even if they haven't accepted the universal jurisdiction of the court, and also through the use of the advisory opinion approach, and we will hear examples of all of those. So with that, I'll now pass over to our first speaker, who's going to give some welcome words. It's the co-president of the World Federalist Movement, which is one of the co-sponsoring organizations for both the event today and also for the global campaign we're launching today. That's Tadashi Inuzuka, as well as being the co-president of World Federalist Movement Institute for Global Policy. He's also a former senator from Nagasaki, and he was very instrumental when he was a senator in building political support for ratifications of the International Criminal Court, and he also is the executive director of a regional common security initiative called the 3+3 Coalition for Northeast Asia's nuclear weapon-free zone. Mr. Inuzuka is joining us online, so Tadashi, we welcome you and look forward to your opening welcome words.
Thank you, Alan. Can you hear me?
Yes, very well.
Okay. I'd like to congratulate for the inauguration of Law Not War campaign, and thank you very much, Alan and Rebecca, for the preparation. And I'm honored to see Sir Kenneth, although it's online. I'm honored to see you. And of course, this campaign is looking into compulsory jurisdiction of the ICJ, as an international organ. It's normal to listen to the opinion of the ICJ. What that is mean is willingness to show the willingness to resolve conflict by the international law. I think it's a very, very normal thing to do that, but somehow it is very difficult at the moment. And this is something, reviving the international arena. I saw in January of this year, United Nations Security Council chaired by Foreign Minister Hayashi in Japan. Japan, luckily, one of the like-minded states of promotion of the ICJ this time. And I was very happy to see this happening. And this reminds me of the CICC campaign in 2007, which led to the Japanese ratification of the International Criminal Court. At that time, I was really wondering why Japan could not ratify the ICC. Everybody said many things. For instance, probably domestic law is not accordance with the ICC, or maybe we have too much U.S. pressure to the ratification. So first thing I did was to meet with Judge Wada of ICJ. I'm sure Judge Keith knows Judge Wada. And Judge Wada told me that he talked with Ministry of Justice people for 3 days, and he convinced everybody that Japan should ratify the ICC. And I said, why? If everybody is accordance with international law, why we cannot even sign the international treaty like this? He said, well, it's a lack of political will. It's just a lack of political will. So this is where I believe the campaign, like Law Not War campaign, comes in. as a civil society, we can really push the government, especially politicians, who are not really interested in the international law, or they are too busy to think about this campaign. But instead, we as a civil society can push these politicians into this very, very normal declaration of willingness to resolve conflict by international law. And now I think this campaign of law, not war, is really now is the time to, we should together push through this campaign, and I believe it is time to do so. Thank you very much.
Just want to say, make a short comment for those in the audience who are not completely into public international law. But Mr. Inuzuku was just referring to when we talked about ratification. The members of the UN Charter are automatically also parties to the statute of the International Court of Justice. But what he was talking about was the acceptance of the jurisdiction, of the compulsory jurisdiction of the court. It's not the same thing, just to clarify this.
Thank you very much, Tadashi, for the opening welcome words. Just before I introduce our first keynote speaker, just mention that we are recording this session. It will be available afterwards. We'll make it available to all our participants who are online, but also participants here. We will follow up with an email to everybody with that. For those online, you can use the chat session to put in any comments or any resources or links that we think are appropriate to this. We also have a team online who will be adding links to some of the key resources as the event continues. And there is a question and answer box also for those online to put in your questions to the panelists. There will be a short time for question and answer at the end of the presentations. It's now my great honour to introduce our first keynote speaker, Sir Kenneth, who's got up very early in New Zealand. It's 6:30 there, and Sir Kenneth has already been waiting online for a while. Thank you so much, sir, for your patience while we sorted out the technical problems. Sir Kenneth is a former judge of the International Court of Justice. He's also been a judge of the New Zealand Supreme Court, and he is an Emeritus Professor of International Law at Victoria University Law School. His experience in this is well worth waiting for, and we look forward to your comments. So Kenneth Keith, the floor is yours. Ken, do you hear us?
Thank you, Alan. There's still a lot of echoing.
Ken, I think you have two connections open. Can you close one of them? Now try speaking. Can you try speaking now?
Well, I can hear a lot of echoing.
I think we're now okay. Try going now.
Okay.
Yes, thank
Well,
you.
Thank you very much, Alan, for involving me in this. I think too often lawyers, especially lawyers, think that the court is the only way of resolving disputes, but it isn't. If you go to Article 33 of the Charter of the UN, there is a long list of methods of settlement: negotiation, mediation, arbitration, conciliation, regional methods, and judicial methods. So there needs sometimes to be a careful choice being made, and New Zealand over the years has made a range of choices. Sometimes disputes just disappear I think of disputes that may be settled by not resolving the particular problems and issue. The Antarctic Treaty, for example, put to one side, put on ice, some people say, the issue of territorial claims. And that was done in the middle of the Cold War. Another instance of a matter just disappearing from sight is the nuclear ships row involving the United States and other countries. So sometimes disputes just disappear. They are no longer around. And at different times, New Zealand has used mediation, for instance, in respect of the Rainbow Warrior case. And there's good officers as well, which were exercised in that particular case as well. New Zealand in the early 1970s made a significant contribution to the proposal, the row that had arisen after the Southwest Africa cases, those disastrous cases in 1966. New Zealand, on that occasion, referred to the fact that the Secretary General, in his most recent annual report, had made the point that arbitration was not popular either, just as the court was not popular. And that particular document called attention to the great value that could be had by using the court to establish the law in a general way by reference to the continental shelf cases that had been decided in 1969. And soon after those that ruling was given, the court, the three states involved, that's Denmark, Germany and the Netherlands, negotiated a treaty on the basis of the law that had been stated there. And in other cases, it will be a matter of management of resources, for instance. So there is a wide range of ways in which disputes can be resolved. So that's an important matter to bear in mind. But I do think that the ICJ does need greater prominence, especially at the moment, given the troubles it's having. I noticed, for instance, that Syria recently did not appear in a request made by the Netherlands and Canada for provisional measures. And that takes me back to the times of the 1970s when Iceland did not appear in the fisheries case. Greece, Turkey did not appear in the Aegean Sea case, and France did not appear in the nuclear testing cases. They did appear in 1995, although not in their normal academic gear. On the other hand, Arthur Watts, the former legal advisor at the Foreign Office, did properly appear in his Queen's Counsel year of the day. So, on France's side. So, there is a challenge to the court at the moment, and it's a challenge that has arisen in other tribunals as well. One of the important aspects of the court, I think, is the much wider representation of states which have appeared in recent years. They have, for instance, come from all parts of the world, from Eastern Europe. We'll hear later, I think, from Counsel Aotearoa in the Romania-Ukraine case. And so that was an Eastern European case. We had an Eastern European case between Georgia and Russia. There were cases from Africa, many cases from Africa, cases as well from the Americas. And so there's been a wide range of cases and a number of intercontinental cases as well, between Djibouti and France, for instance, Equatorial Guinea and France. And I suppose in a way you could say the Australia-Japan whaling case was another. So New Zealand was involved in that case as an intervener, and it's been an intervener very recently in the jurisdictional phase of the Ukraine-Russia genocide case. So there is an encouraging growth, I think, in the number of cases that have come from other parts of the world, whereas the old court, the Permanent Court of International Justice, was essentially a European court. There are cases now that come from many other parts of the world, and that's been a change over the life of the court. I'm encouraged by the fact that states seem to accept that the court's processes, their commitment to the rule of law, their commitment to getting the facts right, their commitment to getting the law right, all of those matters are prominent in encouraging states to go to the ICJ. But one worry I have is in respect of the election process. There have been some elections recently, in my view, that have been unsatisfactory, with candidates of insufficient caliber being elected. Another matter that I'm afraid does get neglected by states or national groups in nominating and states in the electoral process is the need to have judges who may have leadership qualities, who will be able to consider taking on the tasks of president and vice president, for instance. You need strong leaders within the court for that purpose, but it's not always the case that that is achieved. So I'm happy later to take questions, but those are my immediate reflections on this very important matter of supporting law and not going to war, especially right at the moment with the dreadful situations in Ukraine, in the Middle East, in the Sahel, and in other parts of the world. Thank you.
Thank you very much, Sir Ken. There are some questions that are coming into the Q&A box, but we'll hold those off into the other presentations. I'll now pass to my co-moderator, Jutta, to introduce the next keynote speaker.
It's a great pleasure to introduce Ambassador Juan Manuel Gómez Verduzco. I will not repeat everything that you already read in the program. I will just add that he's currently the head of the working group on amendments for the Rome Statute to the International Criminal Court. And I have had the pleasure to experience him in the special working group on the time of aggression. And also, I remember when you were Undersecretary for multinational issues and human rights in Mexico, and the Ministry of Foreign Affairs was hosting a seminar on the upcoming Kampala Review Conference and trying to achieve consensual solutions for possible adoption of the jurisdictional conditions and definitions for crime of aggression. So I'm looking forward to what you're telling us.
Thank you very much, Dana. Thank you very much for your kind words. If you allow me, I'd like very much to continue on where Sir Kenneth left. And it is about what I see as promising, a promising trend on the resort to the jurisdiction of the ICJ. Indeed, there's been a steady increase in the number of states that have accepted the compulsory jurisdiction, and this is where the very good initiative led by Romania and others has contributed. And of course, one may think that 74 states having accepted the jurisdiction, the compulsory jurisdiction, is too little. But one needs to remind that 36% out of that number accepted it after 2000. So it's quite a recent phenomenon, and we need to continue promoting declarations on the compulsory jurisdiction. But we need also to remind that states come to the ACJ also on the basis of special agreements, to which Judge Kenneth referred, which is a very important also aspect of the jurisdiction of the court. Even states that had accepted in the past the compulsory jurisdiction and then decided to withdraw. When you think about the case of Equatorial Guinea and France, where France accepted to go back to the ACJ on the basis of an agreement. But there is also and in that sense, innovative procedures, like the one that led to Belize and Guatemala to submit their delimitation case as a result of a referendum. Actually, two referenda, one in Belize, one in Guatemala. It was not only the governments, but the peoples who decided to submit a long-standing dispute to the ACJ. And I think this is remarkable, because it shows that more and more, it's not only states, but peoples trust the court and put their confidence in it. And we see also an increase in the result of the court through jurisdictional clauses contained in multilateral treaties. And now, every time we negotiate a new multilateral treaty, almost automatically, when we come to the final clauses that, or those that deal with the dispute settlement, we have a proposal to insert a clause giving jurisdiction to the ICJ. We just did that for the recent treaty of Aotearoa, the BDNJ treaty, and we are doing that already for the next multilateral treaty that will come into fruition, I think, in 2 years' time on cybercrime. And I understand that in Geneva, where they're working on a treaty on pandemics, and in Nairobi, another one on plastics, all these, in all these very specialized treaties, we will find a jurisdictional clause giving the ACJ jurisdiction to entertain disputes related to the implementation or the interpretation of that very convention or treaty. So I think that there is a very positive trend where we see also more and more countries resorting to the ACJ. It's not just those that have gone already a number of times. My region, Latin America and the Caribbean, has become one of the most frequent clients of the court in a huge variety of cases, not only about the limitation, it's also the protection of the environment, it's asylum, that was one of the firsts, or the application of the Vienna Convention on Consular Relations. That was the case between Paraguay and the US, then Mexico against the US. More and more the countries of my region go to the court. It is also true that they go thanks to the Pact of Bogota. The Pact of Bogota, which is the American Convention on Settlement of Disputes, is a driving force behind cases coming from Latin America. What I can see also as a very positive trend is how popular the advisory opinions have become. And not only we will have next year or the next 2 years two very important cases, one dealing with Palestine, the other one dealing with climate change. But what we have been thinking as a new feature that may also expand the access to the court will be to allow the Secretary General to request advisory opinions to the court. What I mean is that the General Assembly or the Security Council, but I think that much better the General Assembly, would give to the Secretary General the authorization on a permanent basis to request advisory opinions to the agency. Why we believe this is a good initiative, which, by the way, was put on the table of the Charter Committee early in the 80s by Javier Pérez de Cuellar, through his legal counsel at the time, Mr. Flash Howard. But the idea is that behind every single dispute, there are legal arguments. And if the Secretary General was one of the persons best informed in the world of everything that happens on the planet, where even in that authority, he or she could very well perhaps prevent a larger conflict by requesting the ACJ to pronounce himself on a matter of law that will be put to it by the ACJ. Of course, I will not get into the politics. I know that it is not easy. There might be even reluctance to that, but we believe it's a way of giving more access to the ACJ. And one final comment from my part would be that we generally agree that the rulings of the ACJ are implemented, complied with by the party, generally. But in some cases, it's not a lack of political willingness that makes one party not to comply with the ruling. There are cases in which it's a lack of technical means or even financial means. And I think that the Secretary General, again, has put a very good example by helping, in a more or less recent case, two African countries, namely Cameroon and Nigeria, to comply a ruling from the ACJ by providing them with those technical means that they need. And 2 years ago, when the president of the ACJ participated in the Security Council, when Mexico was a member, an elected member, of course, and under Mexico's presidency, the president of the ACJ said that this is a very good precedent. This is a way in which we could promote a better compliance with the rulings of the ACJ by engaging with the Secretary General, and the Secretary General, of course, will not take sides, but will just allow or help the two parties to comply with them. So, to put it simple, I am quite optimistic about the result to the ACJ, even if, of course, there are cases, and one that you, Sir Kenneth, just mentioned. But given the state of affairs in present days, the fact that we see so many cases out of the docket of the ACJ is now 20 pending cases, plus 2 advisory proceedings pending as well. It is remarkable if we only compare these figures with what we had during the whole. Thank you very much.
Ambassador Gómez Robledo, thank you very much. Really interesting comments on the use of the court and how it is done through different approaches, not only from those countries that have already accepted the compulsory jurisdiction, but also through the mutual agreement and through the use of treaties, and how, particularly in Latin America, that has increased the use of the court. your very interesting idea of empowering the UN Secretary General to request advisory opinions. That's something I'm sure that our campaign, which will be launched later today, Rebecca Shoup will do the launching of the campaign Law Not War. I think that's something we really want to pick up because it's a really interesting idea. And on the advisory opinions, just to note, if you're not already aware of this, that the International Court of Justice has extended the timeline for accepting written submissions on the climate change case until January the 20th of next year. So if your country is considering to put in a submission, there's still time. And the court has also opened up a little bit to international organisations, and there are some who have already been given the permission to put in written submissions. So that's that case is well worth watching, of course, of interest to everybody. And of course, that advisory opinion was requested by a UN General Assembly resolution that had no opposition. So I think the judges are going to see this as a really important case, seeing virtually every country in the world is behind the court attending to the legal obligations of states with regards to climate change. So thank you so much, a lot of food for thought there. And it's now my great pleasure to be able to invite our next, our final keynote speaker to speak, and then we'll move to our next round of speakers. And that's Professor Dr. Aotearoa, who's the former Foreign Minister of Romania, a member of the UN International Law Commission, and has been an agent of Romania before the International Court of Justice, and was instrumental in the move of Romania to accept the compulsory jurisdiction of the International Court of Justice, and through that experience then has led the like-minded initiative, the Declaration, to increase the acceptance of ICJ jurisdiction. Professor Aotearoa, it's a pleasure to have you here, and we look forward to your comments.
Well, thank you so much for this opportunity, and thank you so much for the idea to put together this event, which is basically promoting the acceptance of the jurisdiction in various ways, of the jurisdiction of the International Court of Justice. It's such a pleasure to see Sir Kenneth once again. I've seen him on the bench. In our case, maritime delimitation in the Black Sea, and I'm very glad to see you again. And I'm also glad that I have the privilege to address you not only as a former Foreign Minister of Romania, which had the initiative to promote the ICJ jurisdiction 2 years ago, but also as a member of the International Law Commission, and also as a candidate for the International Court of Justice. I can but agree with what Judge Keith mentioned about the caliber of the judges of the ICJ. I think the promotion of the jurisdiction of the court is extremely important, especially nowadays when we are traveling through such turbulent geopolitical times, and I think new ways and modalities for making the acceptance of the jurisdiction of the court more appealing are extremely important, extremely useful. And I think it's important, especially taking into account the fact that international justice, international law for small to medium-sized states in the international community, they are very important. Romania is such a small to medium-sized state, and for us, international law is in the very core of our foreign policy. For us to accept the importance of fully respecting the full body of international law is extremely relevant, because for us this is a way to ensure stability, predictability, and security in international relations. And in this way, we can maximize the efficiency of our foreign policy demarches. And this is valid for more than 110 states, which are members of the United Nations, which are small to medium-sized states. And I think that's why the accessibility of the ICJ is extremely important. And especially then that we have such resilience tests to go through. Well, how this idea of launching a campaign for promoting the jurisdiction started 2 years ago. As Judge just mentioned, Romania had an important case, the maritime delimitation case, in the Black Sea before the court. It was finalized in 2009. I had the honor to be an agent of Romania for this case. And this case was submitted to the court by means of a compromissory clause. included in a bilateral treaty, a neighborhood treaty with Ukraine. And it is extremely important that the judgment in this case was passed with unanimity and without any dissenting opinions or other declarations by the judges, which is by now a unique case in the case law of the court. So a very solid judgment, which for us also for Romania was important because around 80% of the disputed area was allotted by the court to Romania in that case. That is around 10,000 square kilometers of continental shelf and the exclusive economic zone. But what was important was the way the court has arrived at this decision. I'm not going to get into technical presentations of the method of the limitation. But what was really important was the fact that at the end of the whole proceedings, that both parties to the dispute accepted the judgment of the court without any kind of comments, without any kind of reservations. That means that the judgment and the way the court has reached that judgment was sustainable, and this is extremely important in order for the judgments to be implemented. And then in November 2020, I had the privilege of having a very important discussion with the then president and the current registrar of the court in the Fed during a visit which I paid as foreign minister at that time. And the idea of launching this campaign for accepting the jurisdiction of the court by as many states as possible has been fled out of that discussion, which was extremely important. So on the 24th of June 2021, we have launched the first steps in order for this campaign to be promoted, and then in November we have adopted the declaration that was just mentioned, and the campaign was formally launched. And I'm grateful to the core group of supporting states, which was composed by Japan, by Liechtenstein, Mexico, Netherlands, New Zealand, Norway, Poland, Spain, and Switzerland. And together we have worked on the substance of this campaign. We have negotiated the text of the declaration. Romania is depository of this declaration, and currently 33 states have endorsed the declaration, the most recent one being Malta on the 9th of March this year. And I hope that the debate today will also give an impetus to the acceptance of the jurisdiction of the court, and perhaps we can find new avenues of how to promote the acceptance of the jurisdiction of the court. The declaration, which I invite everybody to read, refers to the ICJ's important role in promoting the rule of law globally, and inventories the main reasons. What are the main reasons for accepting the court jurisdiction? First, the competence over any legal dispute among states. Then, the vast expertise in dispute settlement, its efficiency and affordability as a dispute settlement mechanism. Of course, this can be improved even more. We have already discussed about some possibilities. Its anchoring in state consent as the basis of contentious jurisdiction, its contribution to the realization of the principles and purposes of the United Nations, such as the maintenance of international peace and security, and not least the declaration encourages states to have recourse to the ICJ and to confer jurisdiction by any means envisaged in the statute. And of course the declaration elaborates on the possibilities, which are the avenues for accepting the jurisdiction. Of course, the unilateral declarations are very important, as the one which was also adopted by Romania in 2015. During my first mandate as foreign minister, I have promoted, and I was successful in convincing the Romanian parliament for passing a piece of legislation by which Romania has accepted the compulsory jurisdiction of the ICJ. At that time, we were the 72nd state to accept the compulsory jurisdiction, and now there are 74 states. There were states which withdrawn, as my colleague from the ILC said, well, we don't like any more the jurisdiction, but perhaps we can use other means. But there are also others who have joined the list of states accepting the jurisdiction by unilateral declarations. But we have also, and we are also promoting by the declaration, the introduction of compromissory clauses in treaties, bilateral or multilateral treaties, and also the conclusion of special agreements. Very important for states coming from Eastern Europe, and I think it is really important that also in the composition of the court there should be judges coming from that part of Europe, because there are cases which are coming. And perhaps our case that I mentioned is an example in that respect. The withdrawal of reservations to treaties. Many states from Eastern Europe during the communist times have introduced reservations to multilateral treaties, blocking the possibility to go to the ICJ for solving their disputes. And after 1990, these states started to withdraw these reservations. We have done the same in Romania, and we are encouraging everybody to do the same. And last but not least, the declaration also mentions forum prorogatum, which is another possibility for accepting the jurisdiction of the court. Forum prorogatum was used in the past, including in quite recent time, but it needs to be further used. And indeed, there are more and more cases on the docket of the court, more and more complex cases, and some of them are and would be perhaps more technical. That means that the court needs to use experts in various areas. The opinion on climate change is one important example in that respect. And I'm glad that also as a foreign minister, I took the decision for Romania to join the core group of the 17 states led by Manuel, which promoted the resolution to request the opinion from the court. Very glad that this resolution was adopted unanimously. And as a member of the ILC and also co-chair of the study group on sea level rise, which is now under debate in the 6th committee on what we have done this year on sea level rise, I hope that, and I'm confident that the work of the Commission in that respect will be of some relevance, also for the ICJ when this opinion will be drafted. And of course, I hope that, well, I'm speaking only as a candidate now, if elected, I can bring my expertise also to that opinion. Last but not least, I think it's very important that everybody encourages, by all means, the acceptance of the jurisdiction of the court. And this means that the court will be, well, we have a lot of work to do. We'll have to deal with even more cases. And this is a good thing because, as Professor Bejawi, former president of the court, once said, well, more disputes solved means less jungle in international relations, more order in international relations. That means more rules-based international order, and that means more security for all of us. At the end of the day, individuals, even if are not parties to this dispute before the court, well, they are at the end of the whole bunch of demarches that we are undertaking in order for this world to be peaceful and secure. So, thank you so much.
Professor Aotearoa, thank you very much for those comments, for being here with us today, and also for your leadership on the campaign with the declaration for acceptance of the ICJ jurisdiction. Just a couple of comments, reflections before I introduce the next speaker. I've noticed in the declaration of the 33 countries, I think it's 2 that have yet to actually deposit any instrument accepting cultural jurisdiction. So I think there's an aspirational nature to joining that declaration, as well as one that's reflective of those countries that have already accepted the jurisdiction of the court. I think it's a very positive way that that declaration has been put forward. And secondly, you mentioned in the case that you are agent for, that with the decision from the court, both parties accepted the decision. And the reflection from the President of the International Court of Justice, Joan Donoghue, at the Security Council session on January the 12th this year on the rule of nations, where she was speaking about the practice and the experience of the International Court of Justice, and she reflected that in most of the cases, nearly all of the cases, both parties in contentious cases did accept the decisions. That is somewhat surprising, that here you have both parties, even the one that may have lost out in the decision, accept the decision. It's a testament to the way that the court undertakes its process of deliberations of going into incredible depth on the background and the legal rights and the legal responsibilities that are around, and so provides the capacity for acceptance of both parties in the dispute. And I think Judge Wieramatri made the same comment, and Nishan may reflect on that when it comes to his comments, that in most cases the decisions from the court are accepted and implemented. That's a very positive experience coming out of the International Court of Justice. So with those reflections, I'm now going to introduce Rebecca Shute, who's the Executive Director of Citizens for Global Solutions in the United States, and also the co-chair of the Washington Working Group on the International Criminal Court, and is also one of the key core group of the leaders of the campaign we're launching today, which is Legal Alternatives to War, Law Not War. So Rebecca, the floor is yours.
Thank you, Alan, and good afternoon, Excellencies, ladies and gentlemen here in the room in New York, and everyone joining us online. It is a pleasure to join you today as Executive Director of Citizens for Global Solutions, one of the co-sponsors of the Legal Alternatives to War, Law Not War campaign. CGS is a non-governmental, non-profit, non-partisan, membership-based organization with consultative status with the Economic and Social Council of the UN. We are a member-driven movement with the common goal of a democratic world federation predicated on peace, human rights, and the rule of law, which was founded by some of the greatest minds and peace champions of the last century: Einstein, Rowan Fulbright, Norman Cousins, Ben Behrens, whose motto, Law Not War, animates the campaign we are proud to co-sponsor today. My organization and its counterpart at the global level, which is the World Federalist Movement Institute for Global Policy, remain guided by a declaration of purpose that was promulgated in 1947 at our founding. It begins with the assertion that we believe that peace is not merely the absence of war, but the presence of justice, of law, and of order. And here we believe that the UN Charter provides not only a moral compass towards this vision, but offers an alternative to conflict, an underutilized alternative, in fact, in the institution of the International Court of Justice as a means for the specific resolution of disputes among states without recourse to the threat or reality of violence. So as we embark on Disarmament Week and also on International Law Week, from the experience of participating actively in civil society consultations also around the new agenda for peace, with humility, I must observe that all too often conversations about justice and the institutions that render it are absent from discussions of pathways to peace. Lasting peace necessarily entails the expectation of accountability and intolerance for impunity, and this includes legal accountability. As a lawyer, I find this omission glaring, but moreover, as co-convener of the Washington Working Group for the International Criminal Court, I'm intimately familiar with the important role that civil society can play in rectifying this oversight and supporting the essential judicial institution of the ICJ. And here we commend the leadership of like-minded states, including Mexico, Romania, as well as Japan, Liechtenstein, Netherlands, New Zealand, Norway, Poland, Spain, and Switzerland, as well as the 33 endorsing countries of the Declaration on Promoting ICJ compulsory jurisdiction over contentious disputes. We urge other states to do so. And further, as a civil society organization, we stand ready to support you in this endeavor, just as we supported the establishment and continued evolution of the ICC. Thus, we are proud to partner on the strategic campaign, which combines education about the value and impact of ICJ jurisdiction for a variety of constituencies with advocacy to enhance ICJ jurisdiction. And here, the campaign has 6 primary aims. Number 1, to increase the number of states accepting the compulsory jurisdiction of the ICJ over contentious disputes. Number 2, to encourage more frequent use of the court as a dispute resolution mechanism provided in international treaties through compulsory clauses. Number 3, to support UN bodies to more frequently and effectively request ICJ advisory opinions on critical issues. Number 4, to encourage states to adopt constitutional amendments or legislative measures to affirm the UN Charter prohibition of war and the obligation to resolve international disputes peacefully, including through the ICJ. 5, we encourage states to nominate high-caliber judges with backgrounds that are reflective of the diversity of legal systems and humanity as a whole, as consistent with Article 9 of the ICJ statute's direction that the main forms of civilization and principal legal systems of the world be assured within the court. And lastly, we urge states to provide the ICJ with adequate funding and resources to fulfill its mandate. And here, echo and underscore His Excellency's comments on resources, including technical support, and also creative thinking about realistic financing needs for implementation of decisions. If all this seems ambitious, I take the opportunity to recollect that in 1995, a group of 25 human rights organizations began campaigning for a permanent international criminal court to hold individuals to account for war crimes, crimes against humanity, and genocide. And it worked. And we do not need to will the ICJ into being as we did with the ICC. It is a foundational element of the global legal order. However, it does need our support to realize its full potential as envisioned by the UN Charter. And here I humbly call on all present in the room and the many online to join us in supporting this essential institution's ability to render fair, effective, and independent decisions that make justice visible and present an alternative to war. So thank you all, and I look forward to the discussion today and moving forward with the campaign in the future.
Thank you very much, Rebecca. And just before I hand back to Jutta, just a couple of follow-up points from what Rebecca mentioned. The Legal Alternatives to War, War Not War campaign, which is being launched today, is hosted by Unfold Zero. So those online, you have the link to that in the chat box. For those here, it's unfoldzero.org, and you just look under Be Involved, War Not War, and you'll find the information for the campaign there. It's co-launched by 6 organisations: Aotearoa Lawyers for Peace, that's from New Zealand, Basel Peace Office, Citizens for Global Solutions, Unfold Zero, the World Federalist Movement Institute for Global Policy, and the World Future Council. And then we already have 50 participating organisations, and another 50 organisations have inquired about and will probably also join as participating organisations. So as it's just a launch, that's the start. We envisage it's going to grow, and we invite everybody to participate. I now pass over to Jutta, who will introduce the next 2 speakers. Jutta.
Before I introduce the next 2 speakers, I just want to clarify again that the word compulsory should not be misunderstood. In acceptance of compulsory jurisdiction, it does not mean that states cannot also use conciliation or mediation or any other form of the Pacific settlements of disputes. It may mean that there will be new developments after reconciliation. There may be outstanding questions why the other Pacific settlements may not work. And as long as one of the parties then goes to the court, the other one has to go there too. So just to prevent a misunderstanding about this. Now, with regards to my next task, which I was very much looking forward to, Professor Roger Clark, no bio that you can have Googled or read before would ever do justice to what this man has done on behalf of human rights and peace. Maybe the fastest way for you to get a more of an inkling would be to look at a book of essays that was produced in honor of him on international law and crime and justice. It was called For the Sake of Present and Future Generations. If you just go through the titles of the essays, you will get already an inkling. There's, for example, an essay by Sir Kenneth, which is called on individual criminal responsibility of Dogg's law offending against sound popular feeling, semicolons and commas, which is clearly a reference to the approach of Roger Clark to looking at the commas and to looking at the sound feelings about any kind of matter. And I remember your essay from Dr. Strangelove to Dr. Seuss contributions of Professor Roger Clark in the legal norm against nuclear weapons. This comes from a participation of a conference by New York Law School exploring civil society through the writings of Dr. Seuss. And Roger Clark had the audacity to pick up the butter-bedded book of Dr. Seuss, where you have only implicitly talk about nuclear weapons, but he turned it into the very serious subject of what has international law to say about weapons of mass destruction. Roger, and so forth.
Thank you so much, Eliza. I have to say that the absolute best bit of propaganda I ever did with my children, grandchildren, great-grandchildren is Dr. Seuss's Butter Battle book. If you haven't read it to the kids, buy it and do it. Thank you. Look, I'm honoured to participate in this significant event, not least because of the group of colleagues involved. I note in particular Sir Ken, who taught the first and I think the only course in international law that I ever took, exactly 60 years ago this month. So thanks again, Ken. Alan and I have worked on nuclear and ICC issues since the 1990s. And hiding modestly in the back of the room is my co-author on penal matters involving the International Criminal Court, Betty Holler. Betty is a terrific Slovenian candidate for judge on the ICC in December's elections. When Alan Weir asked me to contribute to this event, I was at a conference in Vienna in which UTA was also participating, celebrating the 25th anniversary of the adoption of the Rome Statute of the International Criminal Court. The ICC and the ICJ are both vital complementary pieces of the architecture for enforcing international criminal law. Both suffer from the same inadequacy, namely the failure of states to accept their jurisdiction fully. This is particularly acute for the ICC in the case of the crime of aggression, where what became essentially an opt-in situation has created a regrettable system similar to that of the optional clause in Article 36(2) of the statute of the ICJ. I noticed that some unseen hand has cleverly deposited in front of most of you a very significant document from the Global Institute on Prevention of Aggression, which is aimed at fixing just that situation. I commend it to you. I share the enthusiasm, obviously, of previous speakers in overcoming the mindsets, the failures of imagination that have led us to the present limitations on ICJ jurisdiction. It is thus that I want to talk a little bit about some of the reasons or the excuses that have got us in that situation. It's worth noting that of the 70-odd states that accepted the optional clause, the UK alone among the P5 has currently done so. It is hard to laud the United Kingdom for its acceptance. During the oral hearings on preliminary issues in the Marshall Islands case on the obligation to negotiate the abolition of nuclear weapons, the UK hinted that if it were to lose, it might need to reconsider its position of accepting jurisdiction, take its ball and go home. In fact, it modified acceptance twice as a result of this case, once during the course of the proceedings and again at the end. The result is a declaration of acceptance which is, like many others, so full of exceptions as to be almost illusory. There are several cases currently before the court, has been pointed out, that rely on compromissory clauses in multilateral treaties. But there are also pitfalls here. When ratifying the Genocide Convention, many states, including India and the USSR, put in a reservation to Article 9 of the treaty, which confers jurisdiction of the court over disputes involving the convention. In one of its early advisory opinions, the court effectively accepted that such a reservation could be made. When the US was finally getting to ratification in the late 1980s, it decided to include what it called the Indian reservation. Perhaps calling it the USSR reservation was a little embarrassing, even for the United States. I had occasion around then to visit the Ministry of Foreign Affairs in Moscow and was stunned to be told that the USSR intended to upstage the United States by removing its reservation of Article 9. It did so early in 1989, and the Ukrainian Soviet Socialist Republic followed suit shortly afterwards. Lo and behold, this is the jurisdictional provision on which Ukraine is relying on its current case against Russia under the Genocide Convention. Reservations to multilateral treaties should be discouraged, and old ones should be removed. Last year, Dr. Bertram Ramcharan, formerly acting UN High Commissioner for Human Rights, published a very creative book entitled Modernizing the Role of the International Court of Justice, which I commend to you. He argues that the phrase, quote, all matters specially provided in the Charter of the United Nations in Article 36(1) of the Statute of the Court is of potential significance in expanding the jurisdiction of the court. I have always thought of it as a dead letter, but Ramcharan makes some good arguments. In a foreword to the book, I commented, based on my own two experiences appearing before the court in cases involving nuclear weapons, and if I may quote myself, I got the distinct feeling in both instances that many of the judges saw these basic issues on nuclear weapons as toxic to their professional health and best avoided. There were exceptional judges up to the task. Part of what needs to be achieved for Ramcharan's brilliant idea, and may I add the current project, is to find a way to select candidates to the court who are up to the job. I leave you with that thought. Thank you.
Many thanks for all this.
Speak a bit louder, Jutta.
Yeah, I wished always that Roger could go on talking whenever he ends his speeches. This is now my introduction to Neshan Tunasekera, who is, how should I say, one of the prime members of the NGO community. He was assistant to Judge Vera Mandri, and we should read all the different opinions to the nuclear weapons case, advisory opinion of the International Court of Justice. You have really followed in his footsteps, I would say. You research human rights, environment, peace, and you advocate for it also very much by now participating, being deeply involved in the preparations for the summit for the future coming up at the United Nations next year. So I give the floor to you.
Thank you very much, Judah. Just to check whether you can hear me.
Yes, very well.
Thank you very much, and again to Alan and everyone involved for this invitation. It's a great honor for both following the great list of speakers who spoke before me, and also, as you said, to share a few thoughts on His Excellency Judge Mr. Gómez, the former Vice President of the International Court of Justice, with whom I had a wonderful privilege period very early in my professional career as a lawyer and as a researcher. And I had, of course, the privilege of going last after many distinguished speakers, so kind of to echo that I agree with what was already said and will not repeat some of it. But to stress on one area that Judge Veeramonti really embarked upon throughout his career and really excelled when he was a judge of the International Court of Justice between the years 1990 and 2002, for the last 3 years being the Vice President, was to utilize international law as an instrument of peace. And this was in fact one of the key pillars of the institution that he founded subsequent to his leaving the International Court of Justice in 2002 in Sri Lanka, of which I became director for 6 years. And he really pushed forth the usage and utilization of international law as an instrument of peace in all sense of the word, by expanding the jurisprudence of the court, by bringing in wider vistas from indigenous systems and cultures and religious philosophy into the jurisprudence of the court, and the nuclear weapons case and his dissenting opinion was referred to. But one of the key messages that he left with me and the generation to follow was really the impact that the International Court of Justice has had as a truly global institution with great prospect to expand. Professor Clark and others were referring to this, how this can be expanded further. And then Alan, you mentioned some of the stories that came with this impact of the International Court of Justice, and several examples were already mentioned by the excellencies before me. One key example that he would always share was the case between Libya and Chad with regard to the issue of the Ausu Strip. Now, Libya to the north and Chad to the south had a dispute over this area, but before getting into a situation of serious armed conflict, both parties or both countries in this case decided to come before the International Court of Justice to solve this dispute. And the International Court of Justice in 1994, as in the case in all the cases, went into detail into the histories and how this land resource was shared between the countries and held in favor of Chad. Now, if there was a situation that Libya was to disrespect this decision, that would have been the coverage of media across the world. But if the alternative happened, Libya and Chad agreed and respected the decision, and then they decided on how this area, in line with the judgment, should be handed over to Chad. And that was one of the many, many ways in which the International Court of Justice had gone into a situation that could have resulted in massive bloodshed, but avoided that. And that's one point I wanted to stress here. The fact that the International Court of Justice statute is read within the UN Charter, and the aspects of preventive diplomacy or peace building or making it a peace institution is a key element that we need to look into it. And soon upon retiring from the International Court of Justice, Judge Virumatri wrote one of many, many books. This one in 2004 called Universalizing International Law, which was one of the key themes he worked on. He asks three questions in this book. He asks, in the 19th century, is there something called international law? And in the 20th century, does international law matter? We unfortunately had to go through two very serious world wars to arrive at the UN Charter and the Statute of the International Court of Justice. And as Sir Kenneth, Keith, as well as Professor Clark just mentioned, much sacrifice had gone into creating this institution, and there's much that can be done, from the Pacific settlements of disputes, clauses that was referred to Article 33 and so forth. Now, the final question that Virumatri asks us is about the 21st century. He leaves this with this caveat that the 20th century was a century of lost opportunity for humankind, and that the 21st century is a century of last opportunity for humankind, given that the dangers of the weaponization of the planet and the mass waste of destruction that we've created for ourselves. And he answers this in this way. He says the 21st century should be the century in which international law prevail against the might of force and other ways and means of which we have settled down disputes during the last 20 centuries and before. And with that hope that we become good ancestors, and those who are going to come after us will look back and say, we tried to move the conversation from brutal force to having law supreme, international law supreme, as a way to resolve our disputes in a peaceful manner, that we were good ancestors. And I believe this is our role as good trustees on our planet for Earth. Thank you.
Before we go to questions, I want to point out that accepting the jurisdiction of the International Court of Justice does not only uphold, it helps to uphold the peremptory norm, namely the prohibition of the use of force in violation of the United Nations Charter. It's also a human rights issue. It helps to uphold human dignity and human freedom because it prevents states, I hope, from turning human beings into cannon fodder and collateral damage and killing tools. And that happens in war even if you do not commit any war crimes.
So I want to thank all the speakers who have been giving fantastic presentations. We have just over 12 minutes, I think, left before we're supposed to close up. We might be able to go 15 minutes. So what I'm suggesting we do, we have a number of questions that have already lodged in the Q&A box. I know there's going to be some questions or interventions from people on the floor. I'm going to first address one of the online questions because it's very brief. Then I'm going to go to some questions from the floor, interventions from the floor. I'll add 2 more questions from the Q&A box, and then we'll come back to all the panelists. We really only have time for one round so that we can get as many questions and interventions as possible and get as many responses as possible from the panelists. So the first one, which is from online, which is actually quite short and easy to do, is the question is there reference to the compulsory jurisdiction of the International Court of Justice included in the People's Pact for the Future, which is being pulled together by civil society under the Coalition for the UN We Need as recommendations for the UN Summit for the Future in 2024, and the answer to that is yes. It's in the interim People's Pact for the Future, and if you want to see that, you see that on the Coalition for the UN We Need website, and thanks to Dan Burrell here, who's one of the key coordinators, and I think Jeffrey Huffines is here also, another of the coordinators, for that civil society process feeding into the Summit of the Future. Now I'll go to anyone from around the floor if we've got any comments and questions, and firstly, can you introduce yourself just briefly and then either intervention or question? Bruce.
Bruce Knotts, and I'm the president of Citizens for Global Solutions. My question is the issue of states using conquest as a way to get territory. And we're seeing this in at least a couple of instances where countries are using military conquest to claim territory, which we know is against international law. What is international law doing to prevent this from happening as it continues to happen?
Thank you very much, Bruce. Other questions or short interventions from around the table or the room? Yes, Shazia.
Shazia Rafi, former Secretary General of Parliamentarians for Global Action, currently President of Air Quality Asia. I look forward to the climate change case that is coming. But my question is related to this case of Palestine. I understand the state of Palestine did take the steps to go through the pre-trial chamber and become part in some fashion of the International Criminal Court. I myself am not a lawyer. Our legal expert, Jari Durhakatin, was my successor, is here as well. But I left just as that was happening at PGA, and I just wonder, given that we've got a live situation of crimes from both sides being committed in a live war right now in Israel and Palestine, how much of the legal framework that these states did join is going to be able to catch the criminal acts after they've been committed in a legal process later?
Okay, thank you very much. Now, just a reminder before I go to the next question or intervention that while we're focusing primarily on the International Court of Justice, a number of speakers have mentioned the importance of the range of mechanisms that are available, and in some of these there will be an interplay between what can happen at the International Criminal Court and what can happen in the International Court of Justice. So when we come to the panelists, I encourage you to look at the broader and not only on the ICJ, even though the ICJ is the main one we're focusing on. I think this is a question, for example, on here, and we want to go a bit broader than the ICJ. Okay, do we have any other comments or questions from around the table before I go to 2 more from online? I don't see any. So 2 more that have come online. One is, can anyone speak about the current case in the ICJ with regards to Rohingya? So that's another of the genocide cases that's there, with quite a novel approach to the jurisdiction that has been employed in order to get that case into the court. And the other one, which had some reference to what Shazi was talking about, but was a bit broader, and that was from Paul from online. What type of interventions or processes could take place in the International Court of Justice, primarily, but maybe also the other ones. We know something's also happening in the ICC with regards to both the Russia-Ukraine conflict and the Israel-Hamas conflict. So those are the questions that we have. I'll go first to Sir Ken. If you've got some replies, responses, Ken, to any of those four questions. Ken? No, you're mute. Can you unmute yourself? Ken, you're still muted.
Maybe the organizer can unmute.
Now speak.
Right, thank you.
That's better.
On the connection between the ICJ and criminal tribunals, my experience just goes back to the role of the ICTY and the Srebrenica case in particular, where the ICJ made use of the factual findings in the ICTY, and that was very valuable. We disagreed with the ruling on law in that case in the ICTY, but we did find the facts as found by the ICTY very helpful. There was also a report, in fact, prepared by David Harland for the Secretary General, and he's another New Zealander. He found that report on the fall of Srebrenica extremely valuable as well. So that's enough, I think, on that point. Just on the question of acquisition of territory by conquest, the Friendly Relations Declaration does attempt to deal with that issue, and I mean, it goes all the way back, doesn't it, to the Stimson doctrine that you can't acquire territory by conquest. So that's enough from me, I think, for the moment.
Thank you very much, Sir Ken. Thank you. And unfortunately, Ambassador Gómez Robledo had to leave for another appointment, but Professor Aotearoa is still here. So can you answer those questions that you
I'll try to refer also to the question of the military conquest. I think not only that the use of force is legal in international law, but there is also an obligation of states not to recognize legal occupation. And that was reaffirmed several times by various international bodies, courts of tribunals, including Security Council, European Court of Human Rights. It's quite clear that such a situation of military conquest in order to occupy territory and conquest, of course, means use of force is absolutely against international law, and international law forbids that. Now, how the courts can react? I think it's important that if courts are competent to act, well, they can be used for provisional measures, forbidding the continuation of such activities. And we have, of course, before us the allegations of genocide case before the court. That was not here.
Thank you very much. And now go to Rebecca. Any comments on those questions?
Sure. I think I would like to take the question on the Rohingya situation, and full disclosure that I was working in chambers at the pre-trial chamber in the International Criminal Court on the companion case that contemplated jurisdiction in different kind of jurisdiction over the crimes allegedly being committed against the Rohingya population. So I think this is indeed a very novel use of the International Court of Justice and an exemplar of concurrent and complementary pathways to justice. So in November of 2019, the Gambia, with the support of the Organization of Islamic Cooperation, filed a case, the Gambia versus Myanmar, with the ICJ, under the auspices of the Convention of the Prevention and Punishment of Crime of Genocide. So both Gambia, which ratified the convention in 1978, and Myanmar are currently litigating this matter before the court. The court is seized of the issue as we speak, and is planning set to contemplate some very compelling questions with matters of jurisdiction. So Myanmar argued that there was no dispute, first and foremost, between Gambia and Myanmar on the interpretation and application of the Genocide Convention. Here, the court ruled that a dispute need not be explicit, that it could be implied, and so forth found in favor of Gambia that the case could continue. Myanmar also argued that Gambia was unaffected by the alleged breaches of the Genocide Convention and therefore lacked standing. And here again, the court threw out that claim and found that all states parties to the Genocide Convention share, I'm going to quote this, a common interest in ensuring the prevention and punishment of acts of genocide. As such, any state, not just those affected by violations, can bring a claim against any other to ensure compliance with the convention. So this is an enormously powerful instance of the use of the court to address atrocities. And it complements, as opposed to contradicts or conflicts with, other ongoing mechanisms. So I mentioned at the outset the case before the International Criminal Court. The International Criminal Court has jurisdiction over personal criminal responsibility and has found in the first instance through the pretrial chamber that there is adequate reason to believe, based on submissions made by third parties and made by the parties of Bangladesh, that there is adequate reason to believe that the crime of deportation was committed, as a crime against humanity was committed against the Rohingya people. The ICC case only contemplates this specific crime of deportation. And the reason being is that it was forced to contemplate the question of territorial jurisdiction, given that Myanmar is not the state party to the Rome Statute. And jurisdiction therefore arises from Bangladesh being a state party. And deportation, in the reasoning of the pretrial chamber, which I supported, is a continuous crime. And so therefore the fact that deportation was occurring on the soil of the recipient country of Bangladesh afforded jurisdiction. And there is also a third mechanism, the independent investigative mechanism for Myanmar, which is a UN body which has jurisdiction that is broader than both of these, actually, because the case before the ICJ only looks at genocide of the Rohingya. The ICC case only looks at personal jurisdiction over the crime of deportation, but the IIMM sees the question of all crimes potentially committed, genocide, war crimes, crimes against humanity on the soil of Myanmar since 2011, and so not just against the Rohingya people, but other alleged abuses of the military. And there's one final point that I will make here, which is that currently representing Myanmar before the ICJ are representatives of the junta, and so there has been a clarification that the ICJ, hearing arguments, taking memorials from these representatives, does not mean that the UN recognizes the junta as the legitimate government of Myanmar. So all that to say that we hope that these concurrent pathways will find justice for the victims and survivors.
Thank you very much, Rebecca. And if we had a whole day, we could go into similar depth on many other cases to see the richness of possibilities that there are involved in the ICJ and in the other complementary measures, which this is, campaign is looking to. We have just a few minutes, well, we're actually over, but we'll stretch a few more minutes for comments also from Roger and then Nisha. Roger?
Yeah, all right, Alan. I want to say just a word or two about taking territory by force. And unfortunately, as I alluded to in my talk, the major powers managed to sandbag the jurisdiction of the International Criminal Court in that context. But there is an important project out there, pursued by Liechtenstein and others, which would enable the setting up of an ad hoc tribunal under the auspices of the General Assembly with the consent of Ukraine to address those kind of issues. And I commend that material too. It requires much more exposition than I can give here. Secondly, the PTA question about Palestine and the International Criminal Court. Palestine has indeed acceded to the Rome Statute of the International Criminal Court. As I see it, potentially there's jurisdiction over both what Hamas has done and what the Israelis have done and are about to do in that context. Again, one would be hard out of do a decent exposition of all of that. It's complicated by the fact that the Palestine Authority, which did the accession to the statute, doesn't have much control over what Hamas does, if any. I don't think that's ultimately a problem to the jurisdictional issue. But I don't think there's any question that these are really significant matters that will be agitated through the prosecutor's office and probably have already started to be looked at in that context. Very, very useful questions. Thank you.
Thank you, Roger. And Nishan, did you want to address any of those questions?
Thanks, Alan. Just to add, I think the responses covers the questions, but I think in the whole attempt today of law not more, and look at the complementarity between the different institutions which you mentioned, including the judgments that have come across this. I mean, given that the Permanent Court of International Justice, we've had almost 100 years of jurisprudence which adds to the work of ICJ, should be taken in line with the other tribunals and ad hoc tribunals that were mentioned. And in all honesty, this campaign, I hope it doesn't take us 22 years to get there, because I think time is of absolute essence, and there should not be any place for war in the 21st century. Thank you.
Thank you very much, Nishan. Just a quick follow-up from what Roger said in the Liechtenstein initiatives in the UN General Assembly. For the UN General Assembly to deal with acts of aggression when the Security Council is prevented from doing that, also opens up possibilities, for example, the UNGA to take an advisory opinion, request an advisory opinion from the International Court of Justice on some of these issues, whether it's on the Russia-Ukraine or on others. And as we've seen, with the advisory opinion, there is much greater attention to the advisory opinions. The number of states participating in the climate case, for example, is phenomenal. And there's much greater attention to the role of the court can play in these advisory opinions, and then the follow-up to those, which is implementation through the body asking the question. So there's a lot of food for thought here. We see a lot of, it's dark times, but it's also some wonderful initiatives that address these dark times and gives us ways of dealing with these better, of preventing some of these conflicts escalating into armed conflict, and how to respond when they do. And thank you so much to everybody who's come along. We look forward to keeping in touch with you as we continue exploring ideas and taking forward and supporting the like-minded group that Romania has sort of brought together with the declaration. And thank you so much for coming. Sorry for taking a bit too much of your time, and have a wonderful afternoon.